A constitutional system can look stable on the surface while quietly producing uneven results underneath, and that tension came into sharp focus when the Supreme Court released a unanimous decision that reshaped how courts across the country must evaluate the reasonableness of government action. The ruling did not arrive amid dramatic headlines or a sudden national crisis, yet its implications run deep because it addressed a fundamental promise of constitutional law, that basic rights apply equally to everyone, regardless of geography. Before this decision, the meaning of those rights often depended on which federal appellate court happened to hear a case. That reality placed ordinary people in an unpredictable legal landscape where identical encounters with law enforcement could be judged by entirely different standards. The court's intervention matters precisely because it confronted that inconsistency head-on. At the center of the dispute was not a new constitutional right or a novel theory, but a question about how judges should analyze facts that unfold in seconds. When courts disagree on how to ask that question, the consequences ripple outward, shaping litigation strategies, government behavior, and public trust in the legal system. It is worth pausing at the outset to reflect on how rarely the Supreme Court speaks with a single voice, and how powerful a signal it sends when all 9 justices agree on the meaning of a constitutional command. To understand why the court felt compelled to act, it is necessary to look at the fractured judicial environment that existed beforehand. Across the country, federal appellate courts were interpreting the same constitutional language using conflicting analytical tools. Between 2018 and 2023, more than 240 published decisions addressed this particular constitutional issue, and in roughly 60% of those cases, courts disagreed on the outcome. That level of division meant that the law was unstable in practice. Lawyers representing individuals whose rights were allegedly violated could not reliably predict how a court would evaluate their claims. Success often hinged less on the facts than on the circuit in which the case arose. In some regions, courts applied a narrow approach that focused only on the instant force was used, while other courts examined the entire sequence of events leading up to that moment. This divide produced what many observers described as a zip code constitution, where a person in one state enjoyed broader protection than someone in another. To follow the reasoning that led to Supreme Court review, it helps to clearly distinguish these approaches and mentally track how each would treat the same set of facts. That exercise reveals why the inconsistency became untenable. Even the federal government, aware of the divergent standards, adjusted its legal arguments depending on the circuit, a tacit acknowledgement that the law meant different things in different places. Such a system undermines the idea that justice is blind, and it was precisely this imbalance that laid the groundwork for Supreme Court intervention. The case that ultimately brought this issue before the court did not begin as a sweeping constitutional showdown. It emerged from an encounter that unfolded in less than 30 seconds, involving a routine interaction between an individual and law enforcement. At the outset, there was no immediate danger and no clear sign of criminal activity. The situation escalated rapidly after the individual attempted to leave, prompting the officer to make a 1-second decision that resulted in the use of force with irreversible consequences. The individual's relatives later filed a federal lawsuit, alleging that the force was excessive and violated constitutional protections. What distinguished this litigation from countless others was the way lower courts handled it. Applying the moment of threat rule, the court evaluated only the final instant when force was used and declined to consider the officer's earlier decisions. Under this framework, tactical choices made seconds or minutes before the use of force were deemed irrelevant, as were missed opportunities to de-escalate. Critics argued that this approach produced distorted outcomes. An officer could make a series of hazardous choices that created danger, yet still be shielded from liability because a perceived threat existed at the last moment. Conversely, careful decision-making and restraint received no legal recognition if the analysis stopped at the final second. Studies cited in broader legal debates suggested this rule clashed with modern police training, which emphasizes managing situations proactively rather than reacting only at the point of crisis. The core question that emerged was simple but profound. If someone contributes to a dangerous situation through unreasonable decisions, should the law ignore that contribution when assessing responsibility? That unresolved question propelled the case beyond its modest beginnings and into the national spotlight. Reaching the Supreme Court is notoriously difficult, with more than 7,000 petitions filed each year and fewer than 100 accepted. This case stood out because it exemplified a clear and entrenched circuit split. The petition for review documented how the Fifth Circuit's moment-focused rule conflicted directly with the approaches used by the 2nd, 3rd, 4th, 6th, 9th, 10th, and 11th Circuits. Those courts applied a totality of the circumstances test, examining the entire encounter rather than isolating a single instant. The Supreme Court takes particular interest in such splits because they undermine uniformity in federal law. Once review was granted, both sides submitted extensive briefs, and numerous organizations filed supporting arguments. Despite the attention, few anticipated the outcome would be unanimous. When the decision arrived, authored by Justice Sonia Sotomayor, it delivered a clear and comprehensive rejection of the moment of threat rule. The opinion began with the text and history of the Fourth Amendment, emphasizing that the concept of reasonableness has always been contextual. According to the court, the framers understood that evaluating government action requires attention to surrounding circumstances. The opinion then turned to precedent, noting that for decades the court had consistently required a holistic analysis in similar cases. Prior decisions made clear that context cannot be stripped away without distorting constitutional judgment. The court also addressed practical considerations, explaining that the narrow rule failed to align with how law enforcement officers are trained to assess and manage evolving situations. By grounding its reasoning in text, history, precedent, and real-world practice, the court left little room for disagreement. Observers can deepen their understanding by tracing how each of these elements reinforced the same conclusion, illustrating the court's methodical approach to constitutional interpretation. The consequences of the ruling are far-reaching and immediate. Hundreds of pending cases across the country now require reconsideration under the clarified standard, including at least 47 active cases in the Fifth Circuit alone. Plaintiffs whose claims were previously dismissed may receive a renewed opportunity to present their arguments, this time with courts instructed to consider the full sequence of events. Beyond the courtroom, the decision is expected to influence law enforcement training and policy. Agencies will need to ensure that their use of force guidelines reflect the principle that officers are accountable not only for split-second decisions, but also for the choices that lead up to them. Perhaps the most striking aspect of the ruling is the absence of dissent. Justices, appointed by presidents from different political parties representing a range of interpretive philosophies, all agreed that the Fourth Amendment demands a totality of the circumstances analysis. That unanimity signals how far the rejected rule had strayed from accepted constitutional boundaries. The impact of the decision may extend beyond excessive force cases, shaping how courts evaluate searches, seizures, stops, and arrests wherever reasonableness is at issue. Some researchers are even exploring whether similar reasoning could apply to other constitutional provisions. As the legal system absorbs this ruling, it serves as a reminder that constitutional rights are not self-executing. They depend on the standards courts use to interpret them. When those standards fracture, rights fracture with them. This decision represents a deliberate effort to restore coherence, ensuring that the promise of equal protection under the Constitution is not contingent on geography, but anchored in a shared understanding of reasonableness.